good morning to all the viewers on the Facebook and all the students of Parul Institute of Law, Parul University. Myself, Dr. Rajesh Singh, I warm welcome our honorable guest, who is a senior designated advocate at the Supreme Court of India. First of all, I will go to the introductory part of our sir, and then I will go to the topic. Jaideep Gupta sir is the senior advocate at Supreme Court of India. He has having an experience of 28 years 6 months. He is the senior advocate from August 2002 and having a experience of 18 years 8 months as a senior advocate. Practiced from October 1992 to August 2002, from 9 years 11 months in Delhi. And he has also practiced at the Court of Calcutta from October 1985 to 1992, that is 7 years 1 month. As per his education is concerned, he has studied from St. Xavier College. From higher secondary, he has done from St. Xavier College, Calcutta. And he has done the BSc Economics from the Presidency College, University of Calcutta in 1978 to 98. He is a barrister at the law at 1984 to 1985 and counsel for the legal educator of UK. He is one of the topmost advocates at the Supreme Court of India, and he has also done diploma in the law practice from the City University in 1984 to 85. He has also done MA law from the University of Cambridge in 1982 to 1984. He is also one of the toppest barrister at the law with the Honorable Society of the Lincoln Institution from May 1985 and having having 35 years and 11 months of total practice. Sir, on this platform, I warm welcome now our Dean Sir, Dr. Akhil Sayyed Sir, who is one of the best Dean at Parul Institute of Law, Parul University. Sir, I request Dr. Akhil Sayyed Sir to warm welcome the renowned advocate of the Supreme Court, Mr. Jaideep Gupta Sir. Akhil Sir.
Thank you, Dr. Rajesh. Thank you very much for giving me such a wonderful opportunity that today I'm in front of learned advocate Jaideep Gupta Sahab. Sir, it's my great pleasure. Very good morning, and on my personal behalf of Parul Institute of Law and Faculty of Law, Parul University, I cordially welcome you, sir, at the doorstep of Parul University. Though it's a online platform today, I definitely request you to come down to our university physically also, because when I went through your profile, I said, Dr. Rajesh के सर को तो यहाँ बुलाइए तो हम सबके भाग्य खुल जाएंगे. And the learned person like you, if is there to address my student, it is not only a great opportunity for my students, but also for the dean as well as all of the staff members. So I thank you once again. Thank you for accepting our invitation, and at the same time, I request you to visit our university once the things get settled down and we get relieved from the corona by grace of Almighty. I just would not take much time, because we all are eager to listen from your good self, sir. Thank you, sir. Thank you very much for being with us.
Thank you, Dr. Akhil Sayyed sir, for this warm welcome. Now, sir, now I will talk about the topic. The topic is the public interest litigation, and it is a very interesting topic to not only for my first year, second year. It is for entire, because sir, we have total 3 types of programs, sir: BLLB, BCom LLB, and BBLLB in the 5 year. And sir, we have registered 180 students in the Master of Law, sir. And we have round about 29 students registered in the PhD program, and still the students are enrolling in the PhD program, sir. So on this note, sir, I am handing this session to you, sir. And at the last 20 minutes, sir, we have certain questions will be put by the students to me, and I will put to you, sir. So the session is handing to you, sir.
Thank you. Thank you, Dr. Rajesh. Thank you, Mr. Syed, for your very warm welcome. I hope that you can hear me clearly. And
Yes, sir. Very nicely, sir.
It is my pleasure today to address you on what has become India's primary brand mark almost on constitutional and administrative law reform in the world, what we called public interest litigation, or PIL. In fact, it has become so acceptable that I find people referring it to as PIL. I think PIL is a little too informal for my liking, but that shows how how much it has seeped into people's consciousness and how important a role it is playing today. Let me start today by talking a little bit about the concept of public interest litigation and how it evolved in this country. You see, the Constitution of India was designed to deliver justice to every citizen of India, including the poorest, the most deprived, and those handicapped by ignorance, indigence, and illiteracy. It is a reformative document, the purpose of which was from the outset to transform the social and economic landscape of the country. But the justice delivery system that we inherited from the past, though sophisticated, required the availability of resources and understanding of vast and complicated laws. How then would the Indian courts reach out and render complete justice to the downtrodden, who either had no access to justice or who had been denied it in the past? There was no answer to this question for the first few decades of the Indian independence. And it was only in the 1970s, with the advent of a new generation of judges, of whom we may remember Justice P.N. Bhagwati and Justice Krishna Iyer, who had the vision to extend and modify certain key concepts of our jurisprudence to create a new branch of law known as social interest litigation or public interest litigation. Their arrival happily coincided with the efforts of pioneering lawyers like Kapila Hingorani, Dr. Rajiv Dhawan, Mr. M.C. Mehta, on whose petitioning it became possible for the judiciary to fashion and mold the judicial processes to achieve this aim. The evolution of this subject is referred to in Balco versus Union of India, a 2002 judgment, in the following words. Public interest litigation, PIL as it is more commonly known, entered the Indian judicial process in the 1970s. It would not be incorrect to say that it was primarily the judges who have innovated this type of litigation, as there was a dire need for it. At that stage, it was intended to vindicate public interest where fundamental and other rights of people who were poor, ignorant, and in social and economically disadvantageous positions and were unable to seek legal redress were required to be espoused. It was not meant to be adversarial in nature and was to be a cooperative and collaborative venture and the courts between the courts and the parties so as to secure justice for the poor and weaker sections of the community who were not in position to protect their own interest. That's the end of the quotation. Another way in which this category of legal action has been defined is taken from a definition formulated by the Council of Public Interest Law, set up by the Ford Foundation in its report on public interest law of the US in 1976, which has been quoted and approved by the Indian Supreme Court in Dr. B. Singh versus Union of India, a judgment of 2004. The following words are used. Public interest law is the name that has recently been given to efforts to provide legal representation to previously unrepresented groups and interests. Such efforts have been undertaken in recognition that the normal marketplace for legal services failed to provide such services to significant sections of the population and to significant interests. Such groups and interests include environmentalists, consumers, racial, ethnic minorities, and other groups. Now, in order to achieve this objective, the bench set about redefining the boundaries of certain key concepts of jurisprudence which had been hitherto applied by courts in this country. The what I wish to emphasize is that this form of action is rooted in our existing jurisprudence, but there are certain extensions, some relaxations, which has led to these remarkable results. The first and foremost amongst the concepts that had to be reshaped was the concept of locus standi. Locus standi can simply be stated to be, and I'm quoting the Black's Law Dictionary 7th edition definition of locus standi, to mean the right to bring an action or to be heard in a given legal forum. It's as simple as that. But the traditional principle of locus standi was that only the person whose rights have been violated can move the court for redressal. If a substantial part of the population of the country is too poor, too illiterate to understand their legal rights, whether a wrong or an injury has been caused to them, the existence of the right and the remedy would itself be rendered illusory. Traditional law did permit one or more of members of a class or persons who had a common legal interest to approach a court for redressal of their grievances. This is known as a representative action, and the law relating to representative action is contained in Order 1, Rule 8 of the Code of Civil Procedure, which, as you all would all know by now, that where there are numerous persons having the same interest, one or more persons out of them may, with the permission of the court, sue on behalf and for the benefit of all these persons. But even a representative action was not adequate to cover the situation that I was speaking of just a few minutes back, as no person belonging to the class concerned might be in a position to come forward. It was therefore necessary to take matters one step beyond representative actions and widen the scope of locus standi. The classic definition of this extension for the purpose of public interest litigation is found in S.P. Gupta versus Union of India, a 1981 judgment, which lays down the following seminal proposition. I'm quoting, "Any person may move the court for judicial redress where a legal wrong or legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal rights. But the individual who moved the courts for judicial redress in cases of this kind must act bona fide with a view to vindicating the cause of justice." Actual examples of categories of persons who faced challenges in approaching the court and whose rights were protected by the courts in India under public interest litigation includes prisoners in jail, women in mental homes, children in juvenile institutions, tribals and other communities living in remote areas, and workers and laborers who could not be expected to access courts. Sometimes the class affected could be an entire community, or indeed the entirety of the citizenry of the country. Prime examples of such situation have been the protection by courts of the damage which is done by environmental degradation, which is a matter which affects not one group, not one individual, but the whole country. While expanding the concept of locus standi, limits no doubt had to be maintained. To this end, the court would have to check the interest of persons in whose favor the court is relaxing the principle of locus standi. Such persons must be bona fide and must not be acting in private interest masquerading as a public interest. In other words, there must be genuine and real public interest involved in the litigation, and it cannot be instituted by anybody in their personal causes or to satisfy their personal grudges. The court would not relax the rule of locus standi unless it is shown that conditions exist which is sufficient to permit the relaxation of the rule. In Ashok Kumar Pandey versus State of West Bengal, which is a 2004 judgment, the Supreme Court went on to say that the writ petitioner who comes to court for relief in public interest must not only come with clean hands like any other writ petitioner, but also must come with a clean heart and clear objective. They must not act for personal gain and private profit or political motive or any oblique consideration. Busybodies will be thrown out at the outset, and in proper cases, exemplary costs may be allowed. One example of how litigation, public interest litigation came to be misused was the famous case of Shachidanan Pandey versus State of West Bengal, a 1986 judgment, where at the behest of a rival organization, a hotel was obstructed from coming up next to the Calcutta Zoo. The next significant set of traditional principles that the court felt necessary to relax or expand were of procedural nature. The natural procedural remedy which suited this form of litigation was Article 32 of the Constitution as far as the Supreme Court is concerned, and Article 226 of the Constitution as far as high courts are concerned. Now, a substantial body of jurisprudence had already developed over time as to the principles and the practice which has to be followed in approaching a court under these provisions. Even though it was recognized that the strict principles of procedure would not stand in the way of affording relief under this jurisdiction, it was still necessary to follow basic principles which were laid down. For example, a petition was still expected to prepare a petition in a format mandated by the court in its rules and guidelines, give evidence in the form of an affidavit, and present matters in a manner to the court where the court could adjudicate. But such restrictions, as you can understand, proved to be too constricting when dealing with public interest litigation. So therefore, the court, while accepting that certain procedural laws would apply, also recognized the concept of writ petitions itself had to be enlarged. Even a letter addressed to the Supreme Court came to be treated as a writ petition. If the court's attention was drawn to an injury or legal wrong, the court was cast aside all technical rules. However, while treating a letter as a petition, the court must prima facie satisfy itself based upon the credentials of the informant, the nature of the information, and the gravity and seriousness of the complaint that there was a genuine case to be looked into. If the court is so satisfied, it would not insist upon filing of an affidavit and would proceed to investigate it on their own. If, however, such prima facie satisfaction was not possible, in that event, it might insist upon an affidavit before issuing notice. An example of one such proceedings is found in laborers working on Salal hydroelectric project, Salal, of the state of Jammu and Kashmir, a 1984 judgment. This litigation was started on the basis of a letter addressed by the People's Union of Democratic Rights to Justice D.A. Desai of the Supreme Court, enclosing a copy of a news item which appeared in the issue of Indian Express, pointing out that a large number of workmen working on the concerned hydroelectric project were denied the benefit of various major laws and were subject to exploitation. The letter was treated as the writ petition. The Union of India and other parties were noticed and they were asked to respond, and then the proceedings continued as usual. Not only are the procedural rules relaxed relating to initiation, but in order to achieve its goals, the court had to devise various innovations in order to overcome the lacunae which may arise in such situations. A clear example of this is the fact that there is no detailed material or evidence provided to the court to go into. In order to overcome such issues, the court may have to make suitable arrangements for gathering evidence. Now, as you can see, this is not a common function of a court. A court in our country takes the evidence as it has been brought on record by the petitioner on the one hand, the respondent on the other, and then come to a conclusion. But here was the court needing to step in and gather evidence by itself. The most convenient way which has been adopted is to appoint a commission or a committee to inquire into the allegations, to submit a report, and then look into the matter. This aspect was dealt with in Bandhua Mukti Morcha versus Union of India, which is a judgment of 1983. In such a situation, the affected party is bound to be at a disadvantage in an adversarial system of justice because of his difficulty in getting legal representation and his inability to produce relevant evidence before the court. That's what the court said. It is therefore necessary to depart from the adversary procedure and apply a completely different kind of lawyering skill and judicial approach. Therefore, the court has evolved the practice of appointing commissions for the purpose of gathering facts. The report of the commissioner will furnish prima facie evidence, which could be disputed by any party by filing an affidavit. The court would then consider the report of the commissioner and the affidavits and adjudicate. The fact that the statement made by the report of the commissioner is not tested by cross-examination would not lead to the conclusion that the report did not have evidentiary value. However, whatever procedure may be adopted by the court, it must be procedure known to law and in accordance with judicial tenets. For example, any procedure evolved by court must conform at all stages to the principles of natural justice. Now we come to another innovation, that of legal representation. Clearly, classes of persons who are unable to access the court cannot be expected to put up adequate legal representation, especially against powerful governmental and private institutions. To overcome this, the court in numerous cases have resorted to the practice of appointing legal representatives themselves in the form of amicus curiae, or, as we say, friend of the court. Two well-known examples of the same is Vinit Narayan versus Union of India relating to the Hawala diaries, and T.N. Godavarman versus Union of India, which dealt with a host of issues relating to mining and forest rights, which was considered and continuously monitored by the Supreme Court. This brings me to another innovation, and that is the aspect of monitoring. That itself is an innovation which expands the limits of traditional law. A well-settled principle expressly incorporated in the Specific Relief Act is that the courts would not pass such orders as may require continuous supervision to enforce. In the case of public interest litigation, we find several instances where the court creating a concept of a continuing mandamus, where from time to time the matters are placed before the court and the court monitors the developments as they take place. Examples are to be found in the host of environmental litigation, which goes under the name of MC Mehta versus Union of India, after the lawyer who was himself responsible for initiating many of these environmental cases. These were some of the procedural aspects which the courts felt the need to innovate on. I have spoken of the innovations in filing of writ petition, in gathering of evidence, in legal representation, and in the process of monitoring. Coming now to the subject matter, which can be dealt with by way of public interest litigation. The instances that have received the attention of court are too vast and too complicated for me to enumerate in this seminar. On a point of principle, it has been said that any aspect which is capable of judicial review can be taken up by way of public interest litigation. This suggests that those aspects which are considered to be outside the traditional purview of judicial review of administrative and legislative action are not to be dealt with in the exercise of this jurisdiction. For example, no political matters are to be taken up under this action. Another clear limit is not to enter into the sphere of policy making, for the reason that the making of policy is an aspect which is not within the purview of the court, but must be left to the executive or to the legislature. It has to go from the point of policy making to a law, then only the court can interfere. It goes without saying, of course, that frivolous and unimportant matters should be left well alone by the courts in the exercise of such jurisdiction, as that would be a tragic waste of judicial resources. I say this only because there are occasional examples of the courts dealing with matters which many of us feel are too unimportant or frivolous for their attention. Coming now to the range of remedies and reliefs which can be granted in the exercise of this jurisdiction, this also has been innovated and widened by the courts in this jurisdiction. The usual public law remedies of certiorari, prohibition, mandamus, and directions are clearly available. That's there in the articles of the Constitution itself. Where necessary, private law remedies are required, then the court will provide the same. A classic instance is in Nilabati Behara versus State of Orissa, a case of 1993, Nilabati Behara, the Supreme Court ordered the payment of compensation by the state for death in police custody, holding the state liable for the tort of breach of public duty. This clearly shows that any legitimate cause of action known to public or private law or any known legal relief can be considered in a public interest litigation. This brings me to a significant and interesting development in PIL jurisdiction. It is obviously beyond the jurisdiction of a court to create law or to direct legislation. However, where there is no legislation governing the field, the court has devised the technique of giving a detailed set of directions, thereby acting in a quasi-legislative capacity under Article 142 of the Constitution. One of the best examples of a comprehensive and exhaustive set of directions formulated by the Supreme Court has to be found in Vishakha versus State, a 1997 case, Vishakha, where, based on certain international treaty obligations and even in the absence of legislation, the Supreme Court pioneered the protection of women against sexual harassment. This celebrated judgment is so important that it became the basis for subsequent legislation by Parliament and is today a beacon, a shining beacon in the contribution of the judiciary, a contribution which is not paralleled anywhere else in the world. Nowhere else in the world do we know a judiciary piloting the protection of women against sexual harassment. Similarly, in Vinit Narayan versus Union of India, which is a 1998 judgment, Vinit Narayan, the Supreme Court reiterated that it could issue directions in the absence of legislation or executive orders to enforce fundamental rights and to do complete justice. Another significant exercise of this nature is to be found in D.K. Basu versus State of West Bengal, a 1997 judgment, D.K. Basu, where detailed directions were given regarding requirements for arrest, treatment of persons in custody, and protection of fundamental rights. This is a very novel form of relief formulation, and this has gone a great extent in effectuating public interest litigation. So what am I therefore saying? It has been my attempt to show that the Indian judiciary, by way of public interest litigation, has sought to address the problem of unearthing legal wrongs against persons or classes who are themselves not in a position to seek redressal from a court of law. That's the original purpose. In order to achieve this objective, the court had to modify and expand traditional doctrines of public and private law. So they borrowed from it but expanded it. In doing so, the courts have to maintain flexibility and constant vigil that the process is not abused. This is the limitation that they have to bring into the process. That litigation is carried on for a bona fide purpose and never for extraneous reasons. Now, briefly, I want to touch upon the criticisms of this system. I won't go into detail on it today. Many criticisms have been made of PIL. It has been alleged that such exercise of jurisdiction amounts to unacceptable judicial activism and encroaches upon the proper preserve of other organs of government like executive and the legislature. It has been alleged that judicial resources have been tied up and wasted in exercising such jurisdiction. Some have complained that many of the problems sought to be tackled by the judiciary are not actually capable of being dealt with effectively by a judicial process, and that no real solutions have emerged even after decades of exercise of such jurisdiction. Now, of course, any experiment and innovation that is as extensive and as radical as attempted by the Indian judiciary through the instrument of public interest litigation is bound to have its pitfalls. It is, however, not possible, after almost 50 years of exercise of such jurisdiction, to even visualize a scenario where the courts will not or should not exercise this jurisdiction. The benefits are so substantial, So many problems have been tackled for which there was no existing remedies, that it is today impossible to conceive of an Indian judicial structure devoid of the jurisdiction exercised under the name of public interest litigation. To take one example from our recent experience, in March 2020, when the country had to enter into a complete lockdown as a result of the outbreak of COVID-19 pandemic, a vast number of migrant laborers and their families found themselves stranded without sustenance and even food and shelter sometimes, thousands of miles away from their native residence. The government machinery was slow to react to this humanitarian disaster that had engulfed hundreds and thousands of citizens in the country. Though reluctant to interfere at first, it was ultimately the judiciary which perceived that without their intervention, a major tragedy could not be averted. At this stage, on their own motion, the Supreme Court and other high courts inquired into the problem and was able to prevent a major disaster by a series of directions, which also form the basis of action by the government. The experience of this problem of migrant labor during the pandemic and the manner in which it was tackled through PIL best exemplify, in my opinion, the principle that has been emphasized by the judiciary from the beginning, that this jurisdiction is not adversarial. It is not petitioner versus respondent. It is not against anybody's interest. It is for the benefit of all. It is when, through the process of judicial intervention, the executive voluntarily takes action to solve a crisis, that the judiciary stands tallest in the eyes of the citizens of this country and can become what it was intended to be under the Indian Constitution. That is to say, the ultimate refuge of the weakest members of our society. On that note, I'd like to stop my comments, and I would welcome any discussion which you would like to enter into.
Sir, it was a very fantastic session. You have startingly elaborated with the PN Bhagwati case, and you have also elaborated with the Locus Pandey. You have also elaborated the Balco versus Union of India, and you have also elaborated Shachidanan Pandey case. And sir, you have also elaborated the various cases on this public interest litigation. You have also elaborated the criticism of the public interest litigation. Sir, we have certain questions from the students which they want to ask you. Sir, what are the penalty and what penalty can be imposed if there is a frivolous and the false allegation or false PIL was filed?
This aspect has, of course, been addressed by the court. The simplest form is costs. There have been other and more drastic remedies which the court has imposed from time to time, because you see, public interest litigation, when it goes wrong, it actually affects or hurts the public interest. For instance, frivolous litigation or even motivated litigation by which a public project, let us say a road building project or a dam, is prevented from continuing, and then 4 to 5 years pass, during which the court sorts out the issues and finally perhaps decides that it is found that the litigation had not been a genuine litigation. What then? You see, then what has happened is 4 or 5 years have passed and the costs of the project has skyrocketed. So the problem cannot be sorted out simply by imposition of costs. Or sometimes when it is found that a mala fide litigation has been brought, then the court will impose sufficient costs, exemplary costs, which might even assist the government to recoup some of the losses which have been caused by the litigation. Of course, there are other things possible. Sometimes we have lawyers who have come to court with frivolous allegations. Their own personal reputation is at stake, and the courts have sometimes adversely commented on their personal reputations and their performance as lawyers. There are other ways. There is no limit to the ways in which we can devise remedies, and if the matter is found to be not bona fide, then the court will certainly have vast powers to rectify the situation. But let me also point out that it is better. It is better if these problems are tackled at the initial stage of the litigation by looking into the motives of the people who have come forward, rather than to allow the litigation to continue for years and then deal with the situation.
Thank you, sir. Thank you very much, sir. We have another question, sir. Sir, pertaining to, we have explained about the criticism on the judicial activism on the enforcement of the legislation. So, sir, can you elaborate this again, sir? Because we have few students have asked about this, sir, on this criticism.
Judicial activism is a difficult word. You see, some people think that judicial activism is a negative concept. But I think, and most of us tend to think, that judicial activism is not a bad word. It's a positive concept. Why? Because this only means that you are prepared, or the judiciary is prepared to move beyond traditional roles which it has played in the past into and to innovate, to create new structures. Now, this is not something which is a negative concept, it is a positive concept. When a judge innovates to address a particular issue, then he is, in a sense, he is being active. But in a sense, he is doing his job, because his job is to solve the problem ultimately. There is no point in a judge saying that, yes, I can see the problem, I can see the solution, but I am not empowered to do anything about this solution. Now, therefore, when we talk about judicial activism, we are not talking about a bad thing. What is, in fact, a problem is, where does it end? That's the question. When does it become overactivism of the judiciary? Overactivism of the judiciary is where they interfere in policy matters. I have not, of course, seen them interfering in political matters. That is, it is too ingrained in our judges not to interfere in political matters. But nonetheless, to interfere in policy decisions is sometimes a problem. And that is where judicial activism or overactivism may be a disadvantage rather than an advantage. There have been examples of interfering with policies. Now, I mean, I have seen yesterday, for instance, a notice going out for the government to explain why a certain class of persons are not being taxed. Now, I would have thought the decision to tax X or tax Y is a pure question of policy, a matter on which the courts have traditionally said that we will not touch unless there is a question of discrimination involved. So I was a little surprised to see that. So therefore, in the course of your day-to-day activity, sometimes a step may be taken which is considered to be too much. But there is something which is a part of our legal system which can rectify it. It's the only system in governance where a person can walk in and say that you have done something incorrect, please reconsider. Now, if the government acts, it is extremely difficult for a person to go and say, you have done something wrong, please reconsider. But if the court acts, then you can easily go in there, file a petition and say, please recall this order, you have done something which is incorrect. So therefore, even in this migrant case, initially they had not agreed to act. It is only later on, when they found from the material that was available in the public domain that things were in a bad shape, that they again picked up the file and they acted on the matter. So see, the flexibility which is available to the judiciary is not available to anybody else. In a public sphere, if you apply that flexibility, then it is good activism and not negative activism. That is what I feel.
Yes, sir. Thank you, sir. You have elaborated in a very systematic way, and you have elaborated the correct answer, sir. Sir, we have one last question, sir. In this COVID pandemic, sir, there are various PIL has been filed in the Supreme Court. So, sir, what is the time limit for the disposal in this COVID for the matter which is taken by the Honorable Supreme Court?
Yes, yes, yes. Now, here, of course, the judiciary is conscious of the fact that these are temporary situations. They require temporary solutions, and that they have to be disposed of urgently and with a deadline. I will give one example. Uh, Parents across the country have struggled this year to pay school fees. They have so many people have taken job losses, they have taken cuts in their salaries, that it has been found very difficult for them to keep up with payments to school fees and all that. Now, at the same time, there are teachers. The teachers' salaries have to be met because they are, even though physical classes are not going on, all through this year, teachers have struggled valiantly to make available online education to students across the country. So you cannot neglect their salaries. Some salaries may come in for increase during the course of the year for various reasons. Um, some facilities are not available this year. For instance, children didn't have to be bused to school. Some facilities like physical activity, sports, laboratory, and all that was not required to be made available for the simple reason that the schools were physically closed. So, therefore, in several parts of the country, public interest litigation started on this issue. What are the balances? What are the checks and balances which can be brought about? It happened in Calcutta, it happened in Rajasthan, it happened in Punjab. As far as I am aware, it may have happened in Madhya Pradesh. Anyway, so the thing is that there the courts formulated responses. They formulated responses like pegging the increases in fees, pegging the increases in salaries, sometimes allowing a 20% cut for everybody, sometimes providing a facility where a parent who is badly affected, but if in particular, is given the opportunity of approaching the school and getting further waiver of fees, etc., etc. So, in doing all this, they have laid down deadlines also. So, the obvious deadline here is one academic year. But what if the pandemic does not free us in 1 year? So, therefore, the orders also have provided that in the event the pandemic exceeds the year and goes into the next academic year, in that event, the schools will have to follow those guidelines till such time as it becomes possible to open up the institutions completely. So yes, they are conscious, and when they are not conscious, there is representation, legal representation of all sides. Anybody can come and tell the court, please take this into consideration. That's why I say that it as a tool, it is very, very flexible, it is very useful.
Yes, sir. Thank you very much, sir. You have elaborated in a very systematic way, and we have got the good answers from you, sir. Now, I will tell Dr. Akhil Sayyed, sir, to give a vote of thanks of this webinar. Akhil Sayyed, sir. Akhil Sayyed, sir. I think he might have some net problem, sir.
Yes.
Sir, on the behalf of Parole Institute of Law, Parole City, I am thankful to you, sir, for giving a precious time for our university. And as per our dean, sir, has already told you and invited you physically whenever, sir, you are free. We always want to invite you, sir, and as per your profile, sir, we are very much obliged that we have with you today on the webinar at this Parul City, sir. Secondly, sir, that this webinar is already being live with all the student and was. If certain question will be put it to me, sir, I will mail you that questions so that if any critical questions is there, it will be replied by you, sir. So on this note, I thanking you, sir, for giving this precious time and the valuable time to our university. Thanks a lot for this webinar, sir. And I am also thankful to Brijesh Kubhani, sir, that who has given a very, very wonderful live for this webinar. Thank you to Jiten Kobhani, sir. Thank you, sir. So on this note, sir, we are closing, sir. Thank you.
you.
Thank you, sir.